My name is Tim Rutherford, and for those of you who don't know me, I'm a charity partner at Stone King, and I'd like to welcome you this morning to our Managing Charity Property webinar. So we planned this webinar several months ago, and obviously at that time we could not have foretold the terrible events of the last few weeks in Ukraine were going to happen, or that issues in the scenario we were going to talk about would be so pressing. But this discussion is, however, quite timely, as only yesterday afternoon Michael Gove provided details of the Homes for Ukraine programme and how people in Britain can take steps to help host refugees from the Ukraine. There are still details to be worked out, but it's clear from the overwhelming crashing of that website that there's a real desire to help those refugees from the Ukraine, and that charities in particular will have a part to play in that process. To quote Michael Gove yesterday, everyone in the UK is in awe of the bravery of the people of Ukraine. The victims of savage, indiscriminate, unprovoked aggression, their courage under fire, and their determination to resist inspires our total admiration. The United Kingdom stands with Ukrainian people. So turning to today's webinar, we're going to be looking at a scenario involving a charity using property to house refugees. And before I outline the scenario, can I first introduce my co-presenters today, who will be well known to many of you. First of all, Hugh Pearce, who's one of my partners at Stone King, specialising in property law issues for charities. Then we have Paul Greenwood from Gerald, who are surveyors that specialise in advising charities on property-related issues. And then the team from Buzzacott of Amanda Francis, Luke Savas and Socrates, who obviously advise charities on financial and tax-related issues. So the format for today is that I'm going to start by outlining the scenario and then lead a discussion with my co-presenters on the issues that arise from that scenario, following which we'll have lots of time for questions. So please raise any questions that you have at any point throughout the event via the Q&A functionality. But it's likely that we will leave questions until the end, as they may well be covered in the series of questions that we're going to be looking at during the session. But you will be able to concentrate without distraction on the conversation, because the session is going to be recorded, and that recording will be shared with you after the event so that you can watch it back as you desire. Finally, as webinar attendees, your cameras and microphones are off, so any questions or comments should be addressed in the Q&A section. And it's worth noting that all of your questions will be kept anonymous. Now, I should also mention that today is focused on the property-related issues. And obviously there are questions around immigration law that arise in this subject, but we won't be looking in detail at that area today. But if you do have any contact with Ukrainian refugees who are seeking advice, we are aware that the Immigration Lawyers Group is providing a pro bono helpline called the Ukraine Advice Project UK to support charities and refugees looking for immigration advice. And we will be providing details of that when we share the recording. So turning then to our scenario. So in the scenario, the charity we're looking at owns a freehold property. And it's been using that property to carry out its charitable activity as part of its charity's mission. However, as a result of the pandemic over recent years, the charity's been re-evaluating its services and has decided that it can no longer carry out that particular activity. It's therefore thinking about how it should rationalise its property portfolio. Now, the charity's decided at this stage that it actually wants to keep the property, but wants to look at using it to provide accommodation for the housing of refugees, given the current climate. So we're going to look at two particular cases. First of all, what happens if the charity wants to manage the housing of refugees themselves as part of their charitable activity? And then secondly, where the charity wants to allow a third party, for example, a local authority or other charity, to use the property for accommodating refugees. And both of these scenarios raise a number of property, legal and financial considerations for the charity that we're going to look at in more detail. So starting with that first scenario of the charity wanting to manage the housing of the refugees themselves, I think if we turn first to Amanda, I think before we look at the legal and practical issues in relation to the property, Clearly, the starting point is often to consider whether the charity can actually afford to use the property in this way. So to what extent should financial considerations be part of the decision? And what are the sort of relevant factors the charity should think about?
Thank you, Tim, and good morning, everybody. Well, financial considerations, including the bigger picture strategy, are definitely important things to think about. When we're dealing with something like the horrors of Ukraine, any decision of this nature, the heart has always got a distinct advantage. But it's important also to listen to your head and enter into this project with your eyes open. One of the first things that you will need to do is to weigh up the complexities and the costs of helping refugees directly against the benefits of doing so. So would, for example, the charity be better off financially, given all of the indirect costs and the other resources that this is going to take, perhaps selling the surplus property and applying the proceeds towards some other form of alternative help, perhaps by making a grant to a specialist charity to benefit those people that you want to help who are refugees. I think the second question is to think about how long does the charity actually see this provisional service being provided for? Is it something that is short-term only because in a few months or a year or so you're going to have an alternative need for this property? And if that's the case, then certainly the cost considerations will probably be something that you might think of quite seriously. Or is it a long-term project and therefore something that your charity believes is worth investing in? The short-term versus long-term plans of your charity are important when you're thinking about the property in question. If the plan is to dispose of the property in the medium term, one of the things to just think about at the beginning is how easy is it for your charity to extract itself from the direct provision that you're going to be providing? And what might be the unintended consequences financially? For example, what's the cost of moving your tenants on at the point where you need your property? Will you have to make staff redundant? Will there be a need to carry out major repair work or refurbishment work to the property in order for you to use it for your medium-term plan? You also need to think about how you're going to finance this and what the income is and what the expenditure is. So will the charity expect to receive any income in respect to the provision of these services? Obviously, the government is going to make some money available, although at the moment, I think that's very much aimed at individual families as opposed to charities. So we will need to see how that actually pans out. But will you be able to obtain other grants and funding, perhaps from local authorities and indeed from the public? But what happens when the public's attention to the plight of these refugees moves on, as inevitably, sadly, it will? In terms of your expenditure, how is that ongoing expenditure going to be financed? This is not something that just incurs initial expenditure, there will be ongoing costs. So where is the income going to come from to finance those ongoing costs? Is it something that you're going to resource by diverting from other existing projects and activities? And if so, what impact will it have on them? And are you thinking about all of the costs, the indirect costs as well as the direct? So for example, the cost of insurance, the cost of possibly safeguarding issues, the cost of compliance generally, as well as the people costs, because people and resources are going to be needed for these services. And finally, very briefly, there are some other complexities I think that you need to give some thought to, all of which have financial implications. So firstly, does the activity fit with the work that the charity is currently doing? Should you be getting directly involved, especially when there are skilled charities out there who are very experienced in this type of work? A specialist charity, for example, will have the resources and the knowledge to be able to give guidance to refugees on how to access the legal system, how to access the state benefit system, how to access schools, GP services, and so on. Very important when you consider that many of these refugees will be women and children. If the decision is taken to get directly involved, do you have the appropriate resources that you need? And that involves people as well as money. And the control structures. So the control structures to enable you to do the basic due diligence on these people. However, however much you believe that that will be limited, there will be a need to make some checks, to think about how you secure your own assets, insurance coverage, and perhaps the need to provide a 24-hour call service, particularly in the early period. Do you have the appropriate knowledge and expertise to deal with the statutory and compliance concerns regarding the property, which I'm sure Paul and Hugh will talk about in more detail? So, for example, the safety of the property, the health and safety aspects, and so on. And how much will all of that cost? Are there other areas of investment or expenditure needed in order to make your property fit for the purpose for which it's going to be used? Are there other costs such as staff and volunteer training, the fitting out of the properties, and so on? And finally, I think you need to weigh up the costs of simply being a landlord, including the legal advice that you will inevitably need, the agreements that you'll need to put in place in due course, ensuring, as I said a moment ago, that the properties are maintained to the right standards, they're secure, they're fit for purpose. The resources to deal with the problems as they arise. When you're dealing with people, particularly people who have been through massive trauma, they are going to need that support. Some of that you might think about outsourcing to other charities and other bodies. And if that's the case, how will that be financed and what sort of agreements will you have in place? So in brief, Tim, to answer your question, yes, I think there are some very significant financial considerations that need to be thought about at the outset. And at the outset, it is important, as I said, to engage your head as well as your heart.
Thank you. And I think turning to Hugh, obviously there's some legal questions. And I think one of the early legal questions is, does the activity fall within the charity's legal objects? And if not, what is the impact of that?
Thanks, Tim, and morning everybody again. Yes, thankfully the charity object question is one I can usually bounce back to you, Tim, or one of your excellent colleagues in the charity team. But obviously a crucial, absolutely crucial point. If it does not fall within your objects, then it is a problem if you're trying to use your assets to pursue something which is outside your objects. Property-wise, it is, I suppose, possible the Charity Commission might give you consent, but I think extremely unlikely. Otherwise, anything you do will need to be on market terms, and that will often be impractical for the delivery of the mission that you're looking to support here. And can I echo a thought there from Amanda as well, that even if it is within your objects and therefore okay for you in charity terms to use the asset for the delivery of this particular mission, can I say up front that I totally applaud charities who have the objects to be able to do this and look to do so, but I have to say, for both legal and practical reasons, it has been my general advice to charities who aren't themselves actually refugee charities doing this work all the time, to think about making use of those who have the skills to do so, other charities who are doing this all the time. And therefore the asset, the charitable asset that you're holding can be used to serve that mission, say by granting leases to them, to enable them to run and manage that service. And I have to say that my experience and general advice has been that that's the best way to deliver that mission object that you're looking to support. So my view.
Thank you, Hugh. And I know in recent years, we've seen charities thinking that sometimes it's more important to be doing something good than necessarily always remembering to stick within your object. But I think coming to you, Luke, if a charity is doing something outside of its objects, does that have any impact on the charity's tax position?
Thanks, Tim, and good morning, everybody. Very much, it does. It's one thing that you do need to consider is the tax. A lot of charities, are aware that there are tax exemptions from what you do, but there are a lot of conditions and there are a lot of pitfalls. And if you're doing something outside of your objects, it's what we call non-primary purpose activity. So something that you do which follows your objects is primary purpose, and it's normally trading, and that is exempt. So doing something that is outside of that, and very much providing housing and all of the services that come with it, is a trading activity and worthwhile, obviously, trying to do good, etc. But again, going back to what Amanda has said, is that actually there are lots of financial costs, things to consider, and tax could be one of them. There is some sort of leeway as well, and there are further exemptions for tax. So, for instance, there is a small-scale trading exemption that charities can enjoy for things that fall outside of their primary purpose. But that is quite limited, and for most of you charities, it will be capped at 85,000, and that is a turnover test, not a profit test. Again, something that charities, with a little bit of knowledge, sometimes forget and think it can be based on profit. Now, profit is the key aim here. For something to be taxable, there needs to be a taxable profit, and by the time you'll actually offset your direct costs in doing this activity, there may not be much profit, but certainly when you actually allocate some of your general charity overheads, you can minimize that profit. However, even when there is no profit or potentially a loss, you still need to report that to HMRC and do a tax return of all of your activities, not just this separate activity, and that can be quite cumbersome. There's quite a lot of detail that needs to go with those tax returns. Again, another cost, another bit of time to take into account. Now, there is, on top of this sort of small-scale trading exemption that I mentioned, the 85,000, it's a reasonable expectation test, and what that means is that at the day one of your financial period, if it's reasonable to expect that you will not go over that 85,000, then it is exempt for that period. So that gives us a little bit of leeway. So if this is a one-off, and it, again, going back to what Amanda and others have said, is that how long is this going to last? If it's a short period that you're doing this, and even if you do actually get quite a lot of income, let's say, but not profit, then in the first year, you don't need to generally worry about it. So that gives us a little bit of leeway. The other thing to think about is, I think quite rightly, as Hugh said, is using another charity who is used to doing this sort of thing and helping to support them. And we'll talk about that in a minute, how you can support them and possibly tax implications there. But often what I get asked is that, from lots of charities, if they're doing something different, particularly commercial activities, can we use a trading subsidiary company to do this? And that again is often quite wise, because it will ring fence the activity within a separate trading vehicle, and therefore also give a layer of protection and risk against a charity. Because again, I'm not touching on the legal side. I'm sure Hugh and others will talk about this later, but this could be a risky activity and infringe upon your other assets and other things you do. Running it through a separate trading subsidiary company not only helps for protection of that, but also ring fence the tax. And without going into great deal of detail, because I could talk about this for an absolute age, is that it is an endorsed sort of structure that charities can use for tax purposes, is to carry on activity within your subsidiary and then donate your profits up, and thereby shedding in potential corporation tax. But again, it's something that I potentially, if it's not what you're used to doing, I'd avoid that. But within reason, there are other sort of opportunities and structures to take on board. So I think on this point, the last thing I was going to say is that if you are doing this, the other thing for tax purposes you need to consider, again, going back to what Amanda said on the financial side, is that how much money you're going to put on top of this. And if it's not within your primary purpose or your objects, if you are actually spending more money, that can be what we call non-charitable expenditure for tax and for legal purposes. And if you incur non-charitable expenditure, then that will take away some of your other exemptions for tax, things like on your gift aid donations and other types of income. So, and this is often not something that people are aware of. If you incur an extra 100,000 on top of your normal expenditure to do this, and it's non-primary purpose within the charity, then you could deny £100,000 worth of tax relief on your normally exempt income. So again, there's quite a lot of things you need to consider and pitfalls. The other thing to think about, again, and I think this is probably more Paul's area than mine, is that using the property as well, you could change your rates position. And now rates are often called a tax. And I think Paul and friends at Gerald are more, are experts on that type of tax. But again, one to consider, if you're changing the use of this, is do you have, an exposure for rates? And actually, if it's not within your charitable purposes, then you could potentially be suffering your business rates or other type of rates depending on the use of the property. So that's my final thoughts, and I'll go back to you, Tim. Thank you.
Thank you, Luke. And that really brings in Paul. So obviously, Paul, Are there any planning constraints on how one can use a property for this type of activity?
Thanks, Tim. Morning, all. And yes, I mean, there certainly are. And I think it really depends on primarily depends on the property planning use and how many refugees you intend to sort of live in the property. The property will need to be capable of being used for residential purposes, which under the use planning class order falls as C3, if you're familiar with the sort of numeric numbering. And if the property is intended to be used by not more than 6 residents living as a single household, that fall under C3, or alternatively, it would need to be classed as an HMO, which is a sort of house of multiple occupation, which falls under C4 use class. And that's sort of for use of at least 5 or more people living together as a single household, which requires a license from your local council, must meet certain standards. If the property's use is classed as sui generis, which convents would generally fall under, where residential accommodation is generally ancillary to the main use of the building, or where building is already regulated, such as care homes and educational premises, the property will not need an HMO license to house refugees. Properties which are liable for council tax, generally speaking, are allowed to be let out on a short-term basis for a maximum of 90 nights per calendar year, without this being considered a material change of use for which planning permission is required. If the property's use has not been established or permitted by your local planning authority, planning permission may be required to change the planning use of the property. This can be done by making an application to your local planning authority for planning permission for a change of use, or alternatively, if you're looking just to formalise or confirm the existing or proposed use is lawful, you can make an application for a certificate of lawful existing use or development, known as a CLUID, to certify the existing lawful use, or a CLOPID for the proposed use. However, this is not planning permission and is generally used to prevent enforcement action being taken against any breach of planning policy. Before considering making any planning application for a change of use for a CLUID, as Amanda touched on earlier, it's important to be aware that by obtaining planning permission for a temporary change of use, you may well inadvertently affect the market value of the property by restricting the use of the property to a specific use, i.e. residential use, or by changing use of the property to a less valuable use. And I would always, in the first instance, suggest checking with your surveyors or property advisors first. Something else to be aware of is that planning conditions attached to the property under the original planning permission may well restrict its use for a specific use, say for residential use or for religious purposes, which may prohibit its use for alternative use, which again could be confirmed by your local planning authority or by your property advisors. And just finally, I think this is probably more of a point for Tim or Hugh, on the legal side, there may also be restrictive covenants on the property's title, which I'm sure Hugh will talk about, which may well restrict the property's use to a particular use, i.e. residential, as I said, or for some religious use. So again, that would be worth checking. So yeah, I think they're the main points, Tim.
And Paul, just sort of a follow-up question on that. If it was a commercial property that perhaps being used as office space, is it complicated to get that changed from a planning point of view?
I mean, the likelihood is that you'll need planning permission to change from a commercial property to a sort of to a form of residential use. But there are, under permitted development rights, there are ways that you can obtain a temporary sort of planning use for a number of years for it to be used for a specific purpose. And I expect in this situation, a local authority may be slightly more lenient in terms of granting a change of use temporarily for use such as this, for, particularly where you're looking to sort of support and house refugees. So yes, I think that's a good point.
Thank you. And turning back to Hugh, I mean, what type of occupancy will the refugees have? Would they be tenants? Would they be licensees? And what's the difference?
Yes, well, depends on various factors. First of all, obviously, if we've, as I'm sure that we would be recommending, got documents in place to evidence the relationship between yourselves and the individual refugees, then clearly what's written in the documents will be a very persuasive aspect of that. Not necessarily divisive, but generally speaking, decisive, sorry, but generally speaking, it should be the basis on which you're considering the occupation. The factual setup is also significant. So how is the space occupied? Are we talking about shared facilities? Are we talking about no rent? If that's the case, then that will tend towards being a licensee as the appropriate form of occupation. If it's a standalone unit, and the more there is rent, that will tend to suggest towards tenancy. But basically, how does the charity want to set this thing up? And usually we're seeing licenses in place, but not necessarily in every case. And there is another point to keep in mind, of course. It may be that the funders to the charity, if there are third-party funders, particularly state funders, may have requirements as to how the refugees are occupying the space, so whether there should be tenants or licensees. What's the difference? That's the next question you asked. Well, there are different bunches of law in landlord and tenant quotes terms which apply to a tenant compared with a licensee. Actually, in this kind of context, they probably come slightly closer together than they do in many others. But if you're a tenant, then, as I say, one bunch of law which will apply. But also, as a key point, the tenancy will bind the landlord's interest. So the charity, if it were to dispose of its free, let's say it's a freehold that the charity holds, if it passes on that freehold interest, then a tenancy will bind that landlord's interest, whereas a licensee technically won't. In practical terms, there are fewer distinctions that might imply, but generally speaking, with licensees, it's a slightly lighter bunch of laws and obligations, mostly a question of contract. But I have to say that does then tend towards the question that Paul's already alluded to of houses of multiple occupation. If you have got licensees sharing space, sharing facilities, and I think that's something Paul is about to comment on. So over to him.
Yeah, so back to Paul. So obviously, if we go down the route of licensees, does that cause more problems with being a house of multiple occupation?
Well, it does. And as a house of multiple occupation to be licensed as a house, I mean, there are some quite sort of strict regulations that local authorities that insist on, and it's mainly around the number of, I mean, it's really around the sort of quality of the accommodation and the shared facilities, just to ensure that, they're safe, they have the appropriate sort of fire regulations in place. There are the general sort of health and safety requirements. I mean, I think other sort of points are that you have to have a sort of gas and electrical equipment has to be sort of certified, and as part of the licensing that has to be sent off to local authorities sort of annually, which is quite sort of standard practice for sort of any residential lettings. And also that you have to have an energy performance certificate, which again is fairly sort of standard practice. But it's mainly around the sort of the right to rent the property. You've got to just check that your tenants have a right to rent the property, and I'll talk in a bit more sort of detail about that sort of later on. But and if anyone's not familiar with what a house of multiple occupation is and how it's defined, it really, I mean, the rules around the licensing have been updated since 2018, and an HMO is, strictly speaking, is a property rented out by at least 3 people who are not from one household. For example, a family but share facilities like a bathroom and kitchen with at least one tenant who pays rent. You've obviously got to check with we suggest that you check with your local authority to just check their own specific licensing requirements. And there's also, as part of the changes in 2018, they've introduced an HMO license for what's known as sort of a larger property. And the definition for that is for properties that are rented to 5 or more people who form more than one household, some of all tenants who share toilets, bathroom or kitchen facilities, and at least one tenant who pays rent. So the same implications, but it's 5 or more people sharing. And that as part of having as being classed as a large HMO, has different sort of knock-on sort of additional requirements in terms of specifications. So yeah, I think they're the main points to consider.
Okay, and coming back to Hugh, in terms of documentation, what sort of documents should the charity be putting in place?
Well, as you just mentioned a little earlier, asking the question about tenancies and licensees, whichever of those 2 appropriate documents should be in place between the charity and the relevant refugee family. Assuming that we're talking about, if it were a tenancy, and assuming we're talking about a no rent scenario, we're talking about refugees, we are trying to support them, so why would we be charging rent? Then the perhaps more usual scenario of thinking about a short-shuttle tenancy wouldn't apply, because it'll fall almost certainly below the lower level for rent provisions that would then make it into a short-shuttle tenancy. So in effect, we're talking about a contractual tenancy, and the terms of the tenancy will be the terms of the tenancy and record the relationship between the charity and the occupier. perhaps more likely and quite often the case is a license arrangement, because it is actually a very personal relationship here. And so it is intended to be a license, and we'd be commending a contractual license, though, as I say at the very start, we'd actually generally be commending you thinking about using a refugee charity to do this, unless you are a refugee charity yourself. Couple of, I think, key things, just a matter of practicality, I'd like to flag up that may not be usual, and one does have to think about in these scenarios. Experience shows that very sadly, you've got, as I think Amanda mentioned earlier, you've got families here, assuming it's a family involved, or even if it's just a one parent and a child, who have been into terrible trauma, generally speaking. I mean, they've had to move as refugees from perhaps a war-torn situation, and whilst and then moving indeed into a new culture. If one thinks back to Syrian refugees some while ago, and those coming from further afield, moving into a UK environment, a UK culture, it's a tremendous impact on that family, and that family doesn't necessarily stay together. And I have to say, I have a direct experience of situations where client charities who do this refugee work are very aware of the implications and having to anticipate the very sad stories of family breakup that do occur. This is consequence of the traumatic experiences that people have had. So it's not just a question of having a stable tenant group. So from a landlord-tenant perspective, a stable tenant group, what happens if the family does break up? How do you deal with that? How do you address that? How do you cater that? Secondarily, you're also dealing with people, obviously, who are being asked to sign up to a contractual obligation to you, and consideration of whether or not they should be having independent advice. You're there to support them, of course. You might well support them in independent advice, but looking forward, and again, Amanda has alluded to this, looking forward to the point where you want that property back for your other missions, and you are being faced, say, with tenants who by then may not want to go. You would want to have as much certainty as you can have that you can get that property back. And in that context, purely with a landlord-tenant lawyer's hat on, it is useful to know that the tenant has had independent advice when they took up the original arrangement. So one of those awkward but practical points that does need to be thought about. And there are, as Paul again has slightly alluded to already, various legal obligations arise, energy performance certificates, fire safety, and depending on where it's an HMO or not, various other elements in relation to fire safety, electrical safety, gas safety, water space heating, that will be consequences of granting arrangements which are either effectively tenancy arrangements or HMOs.
Okay, and I think Hugh, both you and Amanda have talked about sort of the wider support that the refugee might need. And obviously one of the ways of providing that is by perhaps having a warden or volunteers on site who are living there supporting them. Does that raise any issues? Yes,
always thought, again, one has to, I'm afraid as lawyers, think about the disaster scenario and how you make sure you get the property back if things fall out or go bad. We would always be, again, commending, leave aside all the questions about safeguarding, purely with a property hat on, making sure that the appropriate form of documentation is in place between you, charity, and first of all, your, let's say it's an employee. There is a nice shape of law and document to deal with that called a service occupancy, which basically links the occupation of the property to the performance quotes of their duties, and so there's a pretty standard arrangement for that, which listeners may be familiar with. Volunteers slightly harder because there isn't quite as typical a document, and certainly a bit of law around that. So what we tend to do is effectively create a volunteer agreement which reflects the service occupancy arrangement. It's a similar type of relationship between charity and volunteer as it would be between charity and employee. So effectively that sort of a document. I think charities need to recognise that they're going to, if they have a problem, need to anticipate at least 4 weeks notice, because that's a minimum period under a particular piece of legislation to get possession of a property that's being occupied as a residence. And arguably that is if you've got somebody who's on site living there to support the refugees who are there alongside them. Although, of course, there are provisions in relation to your fundamental breach of contract and the like. But again, we would recommend being careful about, particularly volunteers. A volunteer with whom you fall out is going to feel particularly bad about being asked to leave a property that they have been working in to support refugees. So if things start going bad with volunteers, it can be particularly messy. So worth being really quite careful about the relationship and the documentation of that at the point they go in.
Thank you. And Luke, are there any tax implications for the volunteers or staff on site?
Unfortunately, as you suspect, the answer is yes. Yeah, if you've got a volunteer, we'll take volunteers first. Obviously doing this out of the goodness of their hearts and wanting to sort of give back and support this, it's reasonable that they should expect some of their costs and their own expenses to be covered. Now, you have to be careful on this because often with volunteers that charities want to give them a sort of round sum amount as an allowance, etc. And that's not always possible, and that can be deemed to be a salary for tax purposes. Often I'm looking at employment tax here rather than in employment under employment law, although I think about 95% of the time they're one in the same. If you're caught by one, you're caught by the other. But volunteers are quite interesting because HMRC will potentially look at what volunteers are being given as compensation, so as monetary side to cover their expenses. So it's important that you have reasonable expenses for the volunteers, and they are justified and covered rather than just a blanket amount. As I said, otherwise you could get caught under employment tax. The other thing is the accommodation as well. If they're deemed to be employees because of what they're doing and the arrangement with the volunteers, even if they're not getting a salary, is the accommodation that's being provided to them could be a benefit in kind. And I'll say could, and the rules will be pretty much the same as staff, so I'll go on to that to cover both in a moment. So if I talk about staff, then if you are basically displacing staff that you use in your charity to then use to support this service of housing refugees, is that you carry on paying their salary. Again, the problem that I mentioned earlier is if that salary isn't part of you performing your primary purpose, then that salary could be non-charitable expenditure and expose you as a charity to tax, even though you're paying the POA and NI on top. The other thing is benefits as well. So we'll talk about accommodation in a moment, but even if you're providing anything else on top of what you normally do, meals, travel, is where is their permanent workplace now? If you're providing them travel because it's not near to where your office is or wherever their ordinary workplace, then sometimes you can actually pay that travel if it's temporary. But if it's a workplace, often not, that travel won't qualify, even though it seems reasonable to pay them those expenses. So again, that could be a taxable benefit. The accommodation for both volunteers and staff, again, could be a taxable benefit. You have this job-related exemption, and I think if people are needed on site and you can demonstrate that they're needed to be on call 24 hours a day and more than, let's say, 1 or 2 people, because that's the other thing we find often with charities, with properties housing people, is that the HMRC will say, well, it's fine to have a couple, but you've got 10 people on site. Why do you need? Can you justify that? So again, have your case ready there, because if you can't justify it, then they'll seek to tax the provision of accommodation as a benefit in kind. And the other thing that a lot of people aren't often aware of is that it's not just the accommodation. Even those that qualify for job-related accommodation, is the associated living cost will still be taxable on them. So anything that the light and heat, food, other bits and pieces while they're staying there could be a taxable benefit. And that goes across the board for anybody that's being given housing or accommodation by a charity, and one that's often trips up our clients. So be aware of that. But I think that's, at the moment, what I would say on the tax side for volunteers and staff. Thanks, Tim.
Okay. And Hugh, coming back to you, I mean, is there any duty on the charity to check the immigration status of the refugees?
Yes, this sounds like a tricky one, doesn't it, with refugees? It seems odd to, given you're doing it for charitable purposes and everybody's keen to support, that one has to do so. But yes, driven by pre-refugee, to be fair, policy decisions, the government introduced policy which required landlords to check and be able to evidence that they had checked the legal immigration status of their tenants and indeed licensees. If they're licensing, there isn't a get around there. And that is something which is an ongoing duty, in fact. And this, of course, is why it's so important in the refugee context to work closely with the government bodies who can vouchsafe the status. That's either local authorities usually, but also Home Office where, in particular situations. And be aware that there are, with legislation, criminal sanctions indeed, in terms of fines, if the landlord breaches those. And for my part, this is one of the key reasons I think where, again, the route using an experienced refugee charity, or indeed the local authority in some situations can be a better one.
Thank you. And coming back to Paul, I think you touched briefly earlier on about how the charity would make sure that the property is fully compliant from a regulatory point of view. Could you sort of summarise the steps that the charity would need to do?
Yeah, sure. So, I mean, as said, Tim, I mean, really most importantly is that, I mean, as landlords of property, you have a duty of care to ensure that your property is safe for residents and complies with the relevant landlord and tenant and health and safety regulation. Because really, if a resident is injured as a result of a domestic hazard that was not rectified by you, this could be classed as negligence, and the tenants could take legal action, either personal injury or other damages against the landlord. I think in terms of the sort of the main sort of regulatory sort of steps, I mean, obviously you need to comply from a sort of health and safety point of view, which, as I mentioned, requirements such as, you know, the sort of gas safety certificates, electrical installation certificates, energy performance certificates to comply with, you know, energy efficiency regulations. Hugh mentioned obviously the right to rent your property and checking the sort of immigration status of the tenant, and that's clearly, you know, particularly relevant here. And I'll talk a bit sort of further on that later on. And also just to sort of, from more of a practical sort of point of view, the sort of maintenance. I appreciate it's not a regulatory sort of issue, but just really to ensure that the property is in good order, safe, it's being maintained, and it's likely to cause, you know, no harm to any of the tenants, which is just from a practical point of view. So I think that they're the main sort of points I consider. But clearly local authorities have their own, and I'm sure sort of refugee sort of outfits that are, you know, that are dealing with sort of licensing and management. They may well, if you're going down that route in terms of having an agreement with an outsourced sort of charity that deals with it, they may well have their own requirements. So it'd be worth just checking to see what their own particular property requirements are and legal requirements for, you know, for your property itself. So yeah, I think checking with the provider and also your local authority, I think you should be covered from a sort of statutory point of view.
Okay. And Hugh, coming back to you, I mean, obviously the charity may itself be renting the property from the landlord on a long lease, or it may perhaps have acquired funding in order to purchase the property. Does that raise any issues?
Absolutely, thanks, Tim. Actually, if I can take even a step slightly higher up, even if it's a freehold, and Paul mentioned it earlier, if you've got a freehold, you may have restricted covenants on your property, which might affect how you can use the property. I'm sure, I know Paul's going to speak about neighbours in a moment, so I won't steal thunder further on that. But yes, very significant to be checking out that you're not in breach of any occupational document that you're enjoying the benefit of. So if you're the tenant, user clauses in your lease, always check them. Underletting provisions in your lease, you're intending to be underletting or under licensing to the refugees themselves, check that you are allowed to do that. And if you were thinking about doing works to the building, for instance, then alterations is often a thing worth checking as well. So if you were going to do, don't set up anything that relatively material, new walls, new structural work, then check that out in your lease also. And then on funder questions, number one, if you have just a general straightforward bank charge on your property or charge of any nature over your property, you may, under that, the arrangements in the charge itself, need funder consent to be doing, again, under lettings, under licensings. And I'd, again, take a step further than that. If whoever your funder is, be it grant funder, be it bank funder, it is worth checking your funding agreements as if it's a fund agreement specific to the particular refugee mission, then there will be conditions in that, no doubt, which will steer and guide that which you should be doing and how you should be delivering the service that's being funded. But otherwise, check out the provisions in your funding agreements, be they bank funding, be they public funding, to make sure that you're fulfilling everything that's required in there.
Okay. And coming back to Paul, I mean, obviously one of the issues may be if you've got a property in a residential area, that perhaps the neighbours aren't so keen on having refugees living next door to them. How do you go about dealing with that issue?
Well, I mean, clearly it's always very important to, you know, maintain good sort of neighbourly relations. So I think it depends on, probably mainly depends on the number of refugees. I mean, clearly if you're looking to sort of rent a house to a family. I can't envisage there being sort of too many sort of problems. Whereas if it may be a sort of a convent, for example, and there may be 10, 15, 20 families sharing and more sort of foot traffic sort of up and down the sort of street, where it could be potentially sort of more contentious, I would always recommend just notifying neighbours in a neighbourly fashion, perhaps just, a friendly sort of knock on the door to say, look, we're supporting refugees, and, if there are any sort of concerns or issues to contact yourselves, or if it is, if you have an agreement with a local authority or through a sort of refugee sort of housing provider, in that instance, I would recommend that, any sort of neighbourly issues that should potentially be directed through the provider rather than yourselves, because they'll have procedures in place to manage any sort of issues or sort of conflicts sort of internally. So yeah, I think it's sort of common sense approach, and if you feel that it would be beneficial to notify neighbours, to notify them, essentially.
Okay. And obviously, Hugh, you've mentioned a couple of times about the fact that you might need to convert the property maybe from commercial use to residential. So turning to Socrates, does that have any tax implications?
Yes, thank you, Tim, and hello, everybody. Yes, from a VAT perspective, always need to consider the VAT position. The starting point is that normally works are liable to VAT. However, as charitable organisations, the first thing you need to think about is, are there any reliefs that are available for you as a charity? So if you're refurbishing the property, first of all, think about zero rate reliefs, widening doorways, installing ramps, disabled access, adaptations to lavatories. They can all be zero rated, and that's always the best way to mitigate that. However, if you have an existing property which is commercial and you're converting it to residential, there is a particular reduced rate there where the construction services can be at 5%. So it's quite important to determine from the outset what the nature of the works are and whether you can benefit from that reduced rate. The reduced rate only applies to construction services, and depending on the size of the project, if it's a relatively large project, you may want to think about the professional fees that you're going to incur, because professional fees are always liable to VAT at 20%. However, if you know the construction services can be at the reduced rate of 5%, you can use what's called a design and build structure to mitigate the potential VAT on the professional fees as well. So very much depends on the nature of the project. If the value of your works are greater than £250,000, Amanda mentioned earlier, is this a short-term project? Is this a long-term project? You need to bear in mind that any VAT that you incur is likely to fall within what's called the capital goods scheme. And so therefore, you may need to adjust the amount of VAT you originally incurred or recovered over a 10-year period under that capital goods scheme. Touching on something that Luke mentioned, if you decide that you want to put this via a trading subsidiary or set up a separate entity, if you're going to do that, think about whether it's beneficial to have a VAT group registration in place. That may or may not be something you want to do. It very much depends on the financials and what your VAT position looks like. But whenever a charity has a trading subsidiary, think about VAT grouping. And then finally, the income that you're likely to get is probably going to be exempt, depending on whether you're supplying this accommodation yourselves and receiving income, or whether you're contracted with a local authority to do it on their behalf. So again, think about the bigger picture. If you're generating exempt income from this residential property, what does that do to the charity's overall VAT recovery position? Is it going to have an impact? You're suddenly going to have a reduction of overhead costs. So that needs to be factored into any decision-making process and any budgets that you may be allocating.
Okay, thank you. And so coming back really to Amanda, I mean, obviously, how would the charity approach this type of arrangement in its accounts and perhaps in its annual report?
Thanks, Tim. Well, the annual report and accounts for charity obviously is its account for public purposes of how it stewarded its resources over the course of the year. And so any activity of this nature is going to form an important part of the narrative in the trustees' report. And I think what you would need to cover in that is an explanation of the rationale for the work and the support that you have given, the justification for why the charity is doing it, particularly if it's something that's new. So a description of the services provided, the support that you provide, and importantly explain the impact that you have had on the lives of these refugees, the difference that you as a charity have made to their lives since they've come into this country, and really going back to the traumatic impact on their lives that something like a war has had, and what difference you've been able to give, and use case studies, use examples. You can do those by changing names, making them anonymous, but it really brings alive the difference that you've made to these people's way of living and future. Obviously, you will need to reference the financial impact that this service has had on the charity, both in terms of its income, its expenditure, how it's afforded to be able to do this. Talk also about the future in terms of the way that you see the project developing, possibly even scaling back in the future, and also to demonstrate in the trustees report that you have thought about this properly. So you've thought really what the risks of the venture are and how you've mitigated those and addressed them. And then in the accounts, obviously, because it's a relatively new venture, you are going to need to be able to identify separately the income and the expenditure relating to it. The income should be relatively straightforward and probably will be classified in the accounts either as income from charitable activities, or some of it may be pure donations. On the expenditure side, that's probably slightly more complicated. So there will be some direct costs, and obviously they will be easy to identify. But you will need also to think about the support costs or the indirect costs, and how you identify those and how you actually allocate them to this activity as opposed to your other activities. And then finally, I think on your balance sheet, obviously, if you're providing this service directly yourselves, the asset, the property, will continue to be classified as a functional asset, a tangible fixed asset. One of the things that you may need, excuse me, you may need to think about is the rate at which you depreciate that property, and also whether any of the work that you need to do to prepare that property for the refugees should be capitalised, or whether it's written off as revenue. So there are lots of considerations in respect of your report and accounts. The thing I would just focus on, though, is just a reminder that these are the external report to the public of what you've done with your charitable resources, and therefore explaining the purpose for the charity entering into this venture and the impact it's had, both in your report but also in the accounts, is paramount importance.
Thank you. And I think now if we turn to look at the second scenario, because obviously we've mentioned a couple of times that because of a lot of the difficulties we've talked about, it might be worth thinking about working with another charity or a local authority to do this type of activity. I mean, turning to you, Hugh, can the charity simply lease the property at a low or a nil rent to the local authority and let them carry out the activity?
Sadly, a tricky one. Charities Act rules mean that, in effect, as the local authority is not itself a charity, the charity is expected to be looking to recover best terms reasonably obtainable on lettings of its property. There are slightly lighter rules that apply to any lease up to 7 years, but in effect the same principles apply behind that. And certainly if it's for more than 7 years, then there's a fairly chunky extra obligation of getting a Charities Act Affairs report to justify that. And indeed, if it was even a shorter lease, I'd be commending getting advice on the terms of the lease anyway. So in effect, it's being viewed as an investment lease. Now, it's possible that the trustees might be able to frame the disposal in a very restricted way, both to themselves and to their advisor, to make it easier, to be more friendly to the local authority. But I have to say it can't be viewed as a gift, and is very unlikely that you're going to be able to end up with a nil rent arrangement with the local authority.
Okay. And Paul, how would you go about establishing what's the appropriate rent to charge for this type of project?
Well, I mean, as Hugh says, it's a difficult one in the circumstances. Clearly, you as the charity would wish to sort of support the refugees and not charge, you know, a sort of an arm's length sort of market rent. But it's really sort of dictated by the Charities Act. So if it's a non-charity tenant, of course, you know, there is that slight sort of dictation in terms of sort of level of rent. If it's with a sort of local authority or a sort of social landlord, I would expect, you know, the level of rent to be a level that would be supportable by sort of other sort of transactions they've dealt with. So I'm sure they'll have, you know, sort of evidence that they would be able to say, well, we've agreed for lettings of, you know, similar houses or convents or whatever the property may be at similar rents, and provided it's a level that we can justify and support in terms, you know, in our advice to you as your qualified surveyor, then we would be able to endorse that transaction. But it's a bit of a balancing act. And all the usual sort of circumstances would apply in terms of the geographical location, the quality of the property, the use, the obligation, the terms of the tenancy, the usual sort of conditions. But as you said, it's very difficult to sort of agree a sort of a sub-market level of rent or a sort of concessionary rent, unless it's something that your surveyors or property advisors can justify on the back of sort of comparable evidence. So yeah, I think that's the sort of short answer. I don't think there's any sort of hard and fast rule, although I know that there are being worked up sort of government schemes at the moment that are offering sort of incentives towards, say, the like of sort of repairs, to put the property in repair, and sort of lump sums for individual properties to incentivize people. But I've not looked into the detail in terms of whether there's sort of a rent cap or any sort of rent structure in place. But I would always take advice from your surveyor or property advisor or solicitor in the first instance, and it will all be, you know, sort of terms as well as the rent. So, but yeah, there's no short answer, unfortunately.
Okay. And Hugh, coming back to you, does the position differ if you're going to work with another charity as opposed to a third party? Does not.
Okay. Yes, well, as long as the refugee charity that's going to provide the refugee services falls within your charitable objects, then yes, you're in a good place now. So you can take advantage of the exceptions within the Charities Act that allows you to provide up to a full gift of land. So that would allow nil or low rent lease to be applied. If though the refugee charity it falls outside your objects, or some of them fall outside your objects, then you've got a problem that you can't be viewing that charity as falling within your own objects, and so in effect you're back in the same place you were. So unless the refugee charity was willing to take the lease from you on your trusts, in effect, in accordance with the binding nature of your own objects, then you're in the equivalent places you were with the local authority, and we'll need to look at the best terms reasonably obtainable.
And you mentioned there a lease. Would we expect to see a lease in place, and what sort of issues would be covered in the lease?
Okay, so quite a big question there, and I'll try and keep myself within range here, because I could go on forever about lease terms, but we'd certainly recommend looking at with care at the property aspects of the transaction and making sure they're all shaped to serve the specific approved mission that you're looking to deliver. And also to have in mind there the state funding, as there often is, which frames some of that, and make sure the landowner is happy with all that, and that all those points are taken into account. So usually you're saying to yourself, okay, we've got a time limited thing, so we're looking at leases as opposed to freeholds. Might speak to freehold a little bit later, but typically the sort of heads of terms that we'd see for a leasing arrangement would be a whole building. Probably. It's tricky to be sharing a building with a refugee mission, generally speaking, and ideally with a garden. Paul's mentioned the question of neighbouring owners and relationships with neighbouring owners, and that can get more complicated. Indeed, sharing a building with refugees can have major safeguarding complications as well, as you can imagine. So it's generally speaking better to have the whole building parcelled over as a unit to the refugee charity. The arrangement is almost certainly going to be personal. You're doing this because it's that charity, and you're not doing it because it's anybody else. So there's no right to assign here. This is effectively a delivery of your mission through that charity. So you are doing the deal with them and wouldn't be doing it with anybody else. You need to have a term, the actual length of the lease, which is going to cover the approved mission period. And again, coming back to the question of what the funder might need, as well as what the refugee charity might need, as well as what you're willing to see happen with your asset. Amanda mentioned earlier, do you have in mind the future? This is not the last thing that this charitable asset's ever going to do, probably. So consider then, okay, this is clearly being done for a very specific mission use. So the permitted use clause needs to be written in a tight fashion to make sure it recognises that's the little thing that you're wishing to do. It's a big thing, but it's a narrow constrained permitted use. The permission also, of course, must be contained within the ability for the refugee charity to be granting approved, maybe, licenses or tenancies to the validated refugees. You want to think about what controls you may want over that. And you also need to make sure the refugee charity is obviously taking on all the necessary statutory duties in running that refugee service. So all the immigration related right to rent matters we mentioned, HMO issues that Paul's mentioned. And so those should all be things that are passed over as much as you can to the refugee charity, generally speaking. Also think about if they've got funding agreements, or if there are funding agreements that are coming through yourself. Clearly, the tenant needs to be complying with any terms of those. As far as rent, we've said nil or low, probably nil, if you're wanting to give the most amount of gift effectively to the charitable mission. Think about insurance. So usually we'd be recommending the landlord retaining the insurance obligation for the building's insurance, because that's effectively protecting your charitable assets. But query, would the tenant reimburse that? If it's part of the gift that they're getting nil rent, why would you charge them for the insurance rent on top? But a thing to be thinking about as part of the deal, in effect. And then repair is always a big question here, because repair can be a large cost, of course, for a tenant, and so do consider what's best there on repair, and whether that's going to be a whole repair obligation on the tenant, ideally, or you may want to be more generous and consider just internal repairing obligations, schedule the conditions so they don't have to give back the building in a better state than they received it in. Do you think about alterations again, and is there a need for alteration for the refugees charity to deliver its mission, and whether or not consent should be sought from the landlord? Generally speaking, if you're giving a gift, then you should have a greater control over what the tenant can do with the building. And I would also think about break clauses. The term is the term, but there may be fundamental points that are essential for both the tenant and for you to consider in terms of bringing to the end this mission which you are supporting, be it related to funding, be it related to other mission needs for you. So those are things to think about. And as a sort of general property law point, as this is going to be a lease in effect of a business nature, notwithstanding it's being occupied by residential individuals as the resident refugees will be. In fact, as between you and the charity that's taken the property from you, they are operating in landlord terms as a quote business in providing that charitable service. And so you'd want to exclude the lease from the security of tenure provisions that would otherwise apply. There's all sorts of other clauses we'd think about, and you need to think about sort of no nuisance disturbance to neighbours, but that sort of thing can, in this sort of context, can become a trickier debate. But those are the principal clauses that I'll be thinking about. And indeed, someone like Paul, I'm sure will be very closely involved in discussions over those heads of terms.
Okay. And Amanda, what are the sort of the key financial issues one should think about in this sort of arrangement when you're looking at the agreement?
Thanks, Tim. I think Hugh has sort of hinted at a number of these. So particularly if you are leasing this building to another charity, you want probably the lease to be generous. You don't want it necessarily to be a hard-nosed business lease. But on the other hand, you don't want to be stuck with something that becomes an onerous financial obligation on you as the landlord. So looking at the finances is important. So for example, how long is the lease going to be for? And are there going to be break clauses? What happens when the lease actually comes to an end? For example, is there a provision within the lease for the tenant to return the property to its initial state? So what we often refer to as a dilapidations provision. What are the provisions throughout the period of the lease for the tenant actually giving notice, and the implications of you as a charity being left with an empty property and all of the repercussions that can have. So be sure that you are aware of the terms of any break clauses that apply to the tenant, and that you are making sure that you have adequate notice of those break clauses, and particularly if the tenant wishes to break the lease. Similarly, on the other side of the equation, you need to be able to potentially exit the lease, possibly early if you need to. So again, you will need your landlord break clauses. Again, beware of any financial penalties on you as the landlord for breaking the lease early, and the costs of doing so. We've sort of hinted that in some cases this will be an arrangement where the rent is very, very low, or even zero. But does that always have to be the case? So you might start with a lease that has a zero rent, but actually once it is well established, and perhaps the need is not quite as dire as it is at the moment, you might want to turn this into a lease that provides a rent. And again, the lease needs to be able to provide that and set out the basis of any future rent if it is charged. I think one of the important things to think about is, what due diligence have you done on your tenant, on your lessee, making sure that if they are going to pay a rent, they can afford it, but equally they're the sort of organisation that you can have security that they're going to look after your property and manage it properly. And then, as Hugh said, what costs are you responsible for, and what costs are your tenant responsible for, particularly in respect to things like insurance, but sort of refurbishment, repairs, but also furnishing and that type of thing. And lastly, I think, as Hugh has suggested, there are huge complications if this is a shared property. So if it's a property that you're using as a charity, but then you are leasing part of it to another charity to house refugees, not least safeguarding and other things. But if that is the case, then the lease needs to be very specific as to what you're responsible for. There will be common areas. You will need to explain who has responsibility for those, who pays the relevant costs, and so on. But I think the other thing to just go back to is the very beginning of this webinar. I mentioned, really, is this the right thing for the charity to be doing with its asset? And it's thinking about the appropriate rate of return, really financially, on the charity's assets, and what are the opportunity costs, and are there other ways of actually making a much better impact on the need that clearly is there at the moment.
Thank you. And Socrates, are there any tax implications depending on how the occupancy is actually documented?
Yeah, there's a couple of things to think about here. First of all, there's if we grant a lease to another charity to operate, the VAT liability of that lease. If this is residential property, then we don't have the benefit of being able to exercise the option to tax. So it's likely that the grant of that lease will be exempt. The only thing that you may want to think about, if this was a commercial property that you converted to residential, there is a provision there that allows the grant of a major interest in a converted property, which is going to be used for residential purposes, to be zero rated. So if it's a commercial property that's been converted to residential and you grant a lease greater than 21 years, you actually make a zero rated supply. And of course, the benefit of crystallizing a zero rated supply is that you can recover VAT on associated costs. So it's very important to be aware of that. With regard to the documentation with the occupancy itself, again, that very much depends on the relationship you have with the third-party charity. Is it going to be the third-party charity who's granting licenses to occupy? We've recently been involved with a tribunal case involving the YMCA, which is out in the public domain, about what constitutes a license to occupy. And you need to be careful whether revenue would take the view that somehow this is hostel type accommodation that's being provided rather than residential type accommodation. The difference being, if revenue took the view that this was hostel type accommodation, you could actually find that the charge to the individuals becomes liable to VAT rather than being exempt. Hopefully, which should fall within exempt residential use, but again, very important to look at the terms. Revenue seem to take quite a hard line on licenses to occupy and the agreements. In our particular case, they looked at the fact that the license agreement stated there wasn't a landlord-tenancy relationship created, and so therefore there wasn't a license to occupy, and tried to argue the thing was standard rated. So it's important to look at the terms on each occasion.
Okay. And Paul, how would the charity go about negotiating those terms with the proposed tenant?
Well, I always think in the sort of first instance, I mean, if particularly if it's a local authority and a social landlord, I would suggest, and I think you would probably agree, is I would suggest that you offer for them to come forward and put forward their proposal, their sort of terms, rather than you sort of putting forward your terms and your provisions, because you never quite know what requirements or conditions they may attach to their terms. So I would suggest asking the local authority or the operator, social landlord, whoever it may be, to come forward, because there's a high chance that they will have sort of set standard terms that they'll, wish not to try and sort of deviate away from. And then once you have those terms, and obviously Hugh's mentioned the sort of lease lengths, the other sort of the normal sort of conditions attached around sort of repairing obligations and the like, I would suggest then considering those internally and ideally sort of sharing those with your property advisor, solicitor, to get input at an early stage, to be able to, before you sort of negotiate directly, to get input from advisors to be able to introduce break clauses, for example, or yielding up, repairing, dilapidation like provisions. So yeah, I think the short answer is, I'd ask them to come forward with their proposal, and then for you to sort of make a counter once taking, having taken advice from your professional advisors.
And is there any sort of particular due diligence, Paul, that the charity should do on the proposed tenant?
I think, and as Amanda mentioned, I mean, there would be the sort of standard sort of residential checks, and I have to caveat, we as a firm, we're not residential managing agents or residential letting agents. But we're more involved in the sort of overseeing and the management and in instructing an appointment of residential firms. So, my sort of detailed sort of knowledge and experience of the exact sort of regulations and requirements is perhaps not as up to speed as it should be. But I think generally, there's obviously the financial checks, and that's, there's a slight grey area because refugees, for example, wouldn't have bank statements for a sort of a UK bank that you would be able to you'd be able to do your due diligence on to check, or other sort of references ordinarily that you would require as part of a sort of letting here. So I think you have to sort of look at it sort of in the round and be a bit more understanding that, they've obviously travelled over with limited sort of evidence or track record to be able to sort of due diligence. So I think you're taking a slightly more practical view, being a little bit more understanding in terms of the level of deposit that you require, and perhaps sort of factoring that into the rent that you may charge, sort of bearing in mind, because what we don't want to introduce is sort of hurdles for tenants. Clearly you have to protect your interests, but the idea is to be able to support the refugees and provide them with some housing, not to make it sort of too difficult for them or discriminate in any way. So yeah, and there's obviously there's codes of practice that government have introduced in terms of sort of rights to rent and checking immigration status and the like. So I think seeking advice from the government websites and looking at a code of practice specifically around immigration law would certainly be a first port of call. So yeah, I think they're the main things.
Thank you. And turning back to Luke, I mean, obviously, if you're renting the property on a lease to another charity and you're receiving a rental income, what are the tax implications of that?
Yes, good question, Tim. Rental income itself is exempt from corporation tax or income tax. So I should add that I cover all the taxes apart from VAT, which you may have guessed that Socrates covers. But so talking separately about corporation tax, if you're a charitable company or if a charitable trust, it's income tax, you have an exemption from pure rental income, and that's the income under a tenant landlord type arrangement. Where it gets messy is if you are providing other services. So if you're providing sort of general maintenance, other security, anything else that's sort of helping out the occupier, and the occupier in this sense is the person that's renting the property rather than individuals, but you could be providing extra services there, that could turn what is a rental income into trading income, because you're hiring facilities rather than renting a property, a space. And it could be sometimes as simple as if you're providing sort of general maintenance of the property, overall management, security. It could be if it was a commercial property, an office, and you had security there, that it makes sense to carry on that security because you've got vulnerable people. You're now providing security service. Now, going back to what Hugh was saying, was that if you had another charity who objects are aligned with you, that is your sort of tenant, if you like, you could say, well, actually, this is my primary purpose, this is what I'm doing, supporting this charity, doing the same thing. Unfortunately, going back to what is your primary purpose, is it wouldn't necessarily be the provision of security or maintenance, even though your objects are aligned, just because you're supporting another charity doing the same mission as yourself. Just if you were providing finance people to provide bookkeeping services, that actual service itself is not part of your primary purpose. If, let's say, your objects were the support of vulnerable families and children, which obviously would be aligned with this. So you need to look at the service. So that could give you a little bit of a trap for tax purposes. The most important thing to remember is we don't want to put people off from this sort of thing, saying, oh no, it's a nightmare because we've got tax issues. There's always a way to play around these things if I've given you half a day to talk through it. But it's things that people need to be aware from the outset, and that's why I think it's important to speak to your legal advisors, tax advisors, property consultants on that sort of thing. It's not meant to scaremonger, it's just these are considerations, and tax shouldn't be the big driver for this, because, as I said, most of the time there are ways to plan this legitimately. So I think that was probably that's my last comments on that, Tim, before I hand back to you.
Thank you. And just looking at the other aspects of tax, moving to Socrates, if the charity is providing additional services alongside the accommodation, maybe welfare type services, does that have tax implications, and is there a better way to do it?
Yes, it's the provision of welfare services by a charity is ordinarily exempt, and the accommodation is normally seen as ancillary to the welfare and also exempt. However, if you have a contract, let's say with a local authority, we've mentioned local authorities a couple of times here. If you have a contract with a local authority to provide welfare services, it's worth considering if there's a better way of doing things. Bearing in mind local authorities have special rules for VAT purposes in that they can reclaim most of the VAT they incur. You may want to think about trying to break that welfare exemption so that you actually charge the local authority VAT. The benefit, of course, being if you're making taxable supplies, you can reclaim VAT on associated costs. And the normal way of trying to break that so-called welfare exemption is to undertake the activities through a trading subsidiary. So that may be something you want to consider. The local authority won't jump up and down because, as I say, they have special rules regarding VAT recovery, and so will be in a position to reclaim the VAT that's charged. But all of that would involve a bit of careful planning. But again, depending on the size of the project and the sums involved, worth doing, particularly if you've had to spend considerable sums of money refurbishing the property in the first place.
Thank you. And I think one final question. Hugh, obviously we've talked a lot about all of the problems. One way maybe to resolve it would be to simply give the property away to another charity and let them do the activity. Is there anything we'd need to think about if we were giving the property away?
Thanks. Well, first of all, that's a very big deal, obviously, handing over a freehold. So Amanda was alluding earlier to the importance of looking at this from the strategic perspective of the charity and looking long term as well. There are often refugees, and the current situation is one as a very good example, where immediate desires, wishes to do good can drive decisions, and heart and head was, I think, of the things you mentioned earlier on. And here's perhaps one where one has to just sit back a bit as trustees of this asset and say to oneself, is this what this asset is meant to be used for in the long term? And if it is, fine, make that decision. And I'll come in a moment to that, but I do commend the thought that actually, is this what you want to be doing forever? A very familiar former partner of mine used to use the expression, would you write the check? Because land feels like a thing which you can give away and doesn't feel like money. Well, it bloomin' heck is money because it's a valuable asset in this country. And the expression, I think it's a very useful expression, which I use quite a lot, would you write the check for the value of that land if you're going to hand it over? If you don't want to hand over the value of that land to somebody else, then of course you can consider the alternative, which is to still hand over the use of the land by way of handing over the freehold, but reserving value to yourself out of it by way of including clawback obligations. And that will still enable you to pass over the asset itself, but with a view, and therefore with flexibility of use, but with clawback provisions that could attach to future creation of value in a land by sale or some alternative uses, particularly if you then also want to think about imposing a restricted use on the land itself as a freehold. But it's a big deal, and I would say think hard, and consider and sit back before you go the whole hog and go with a freehold, and certainly think about clawback, and certainly think about restrictive covenants and other user restrictions.
Thank you. Well, we've got time now for a few questions, and I see there's a few that have come in through the chat, so let's have a look at those. The first question is actually, it's more of a comment from someone to say, is it worth noting that the law in Wales governing the renting of homes changes on July the 15th, which will have an impact on any agreements for occupancy that last for 6 months or more under the Renting Homes Wales Act? I don't know, Hugh, if you want to just mention that, or...
Thank you. That's very fair. We should have introed this with saying the law in Wales is directed primarily at the law for England, and of course we do historically always exclude Scotland because the law in Scotland is very, very different when it comes to land tenant. But yes, the law in Wales is shifting over time with greater protections for occupiers. And thank you for whoever raised that point. Don't assume if you are a charity with assets both in England and Wales that the same rules in land on tenant terms and property terms apply. The law is steadily diverging from one from the other, and the occupational rights are becoming different and slightly more tenant beneficial within the Welsh jurisdiction. So soon enough, we will absolutely be having Welsh law expertise as a necessary factor for most law firms who are working across both jurisdictions.
Thank you. And I think this is another one, actually, I think for you, Hugh. You touched about the fact that landlords need to do various checks on the immigration status of potential tenants. And the question is, isn't this the job of the Home Office to check the immigration status of people in the UK? Why would we expect landlords to do it? Because in particular, landlords aren't trained to do these checks. And
couldn't agree more. I couldn't agree more. The fact is, the law says that that's required. And remembering that this is, as I mentioned when I was talking about the immigration status checks, this isn't primarily aimed at the refugee. It's really aimed at the economic migrant from policy terms, and that's who the government, when this was introduced, there were considerable concerns about, and the whole immigration question was a question that related to primarily the economic immigration and issue rather than a refugee issue, but it captures refugees too. And I mentioned earlier that we would always commend, when it comes to answering this particular question, of course, deploying the Home Office or local authority, because quite often if it's a refugee scenario, local authority have a delegated role in here as well, and take advantage of them. Very often you are being delivered with a refugee who comes with the validation. This is a refugee in a refugee scenario, so it's hopefully less of an issue. But and certainly with the Homes of Ukrainians scheme, there is an absolute assurance from the I see from the Home Office that they will be carrying out those checks for that particular case. All I can say to you is the law requires it, and the law requires you to keep it. So I wish I could say otherwise.
Okay. And a question that sort of picks up on the last theme that we talked about, which was this potential to perhaps give the property away. And the question is that the attendee was surprised to hear that suggestion, because of course trustees are obliged to maximise the value of charity assets. I don't know, Amanda, if you wanted to perhaps comment on when it's appropriate for a charity to think about giving away assets.
So I think to begin with, if you were thinking about giving away the charity's asset, it would need to be part of your strategy, and it would need probably to be something that was consistent with your objects. So you may be looking at giving the property away to another charity, who may use it for purposes consistent with your own objects, but that you no longer wish to do it. It may be that you're in a winding down situation. It may be that, as I said at the beginning, the option is to sell the property and then donate the proceeds to another charity. Actually, if that other charity says, well, we don't really need the proceeds because all we're going to do with those proceeds is go out and buy a property, you may as well gift the property to them in the first case. So I think there are situations, it won't apply for everybody, But there are situations when some charities, part of their strategy is to basically wind down or to rationalize the assets that are available to them. Rather than gift money and grant money, they may wish to grant property, and that's absolutely permissible. The key thing is to make sure that you're granting it in a way that is consistent with your own objects. And Hugh can probably just add to that comment from a legal aspect.
Yeah, I wouldn't add much more. In my notes a little earlier, I was, you know, my first observation was, "Are you sure you want to do this?" Because it is absolutely a very big deal. But imagine myself are aware of a number of charities over recent years that we've supported who, just through their own capacities, numbers, otherwise, have been blessed with, and indeed stewarded very carefully over many years, some quite significant property assets, and have themselves taken the view that there is another charity which is in a better place, with it has to be within their objects to be able to do this gift, of course, but another charity who is better placed to deliver the objects. It's about the objects. It's all about the objects. And if there is somebody else better placed to do the objects that you want to support there, and you're not in a position anymore to be able to do it, say, well, there's a thing to consider. I would, as I say, really think hard about stuff like, do you want to add extra restrictions, as in land restrictions, over the use? Do you want to think about clawing back if value was suddenly generated in future out of that property? Did you actually intend all the value to go, as well as the use to go, to that other charity? But it has to be a charity, for it to be a gift, has to be a charity that sits entirely within your object.
And if you're a charity that operates internationally, are there any different implications in terms of giving away the property? I think, Amanda, maybe this one for you. I mean, obviously, if you're giving the property away in England, I can't see a difference, but does that affect the overall charity?
I think it does, in terms of, you know, one of the things you always have to be aware of, and Hugh has hinted on it really, in terms of the restrictions that you place on the property going forward, even if you don't have direct title to it. When you give either a grant, financial, a monetary grant, or any other asset internationally, one of the things you have to bear in mind is your duty of care to that asset, and to ensure that that asset continues to be used for the purposes that are consistent with your own charity's objects. So there's nothing to prevent you, provided your objects are wide enough that you can grant or gift assets overseas. You do just need to look at your objects clause to make sure that it's not geographically restricted. But if you can gift assets abroad, you can gift a property, but you then need to be very careful about the property law in the country in which you are gifting to make sure that the transaction is properly and legally secure, but also then to make sure you've got some way of monitoring the continued use of that property, so that you are assured that it's being used for objects which are consistent with your own.
Thank you. And one person's mentioned that we haven't talked anything about insurance. I think, turning to Paul, what would one need to think about on the insurance front?
I think there'd be an expectation for landlords to insure, and, you know, potentially, I don't think you'd look to be sort of reimbursed by the tenant. I think that would just be factored in sort of through the, you know, the nominal sort of rent that's being charged. But yeah, I mean, clearly insurance has to be in place, the usual sort of property insurance, building insurance, and other sort of insurances, sort of indemnity insurances. But yeah, I think that's key to have sufficient insurance. And clearly, you know, you could take advice from your current insurers or others, brokers. But yeah.
Thank you. Well, the same person's also commented that all of this makes it sound nearly as difficult as obtaining an entry visa, and I think that's probably right. I think before we close, I'll just quickly whip round the panel in case you've got any final sort of last comments you'd like to throw out. Maybe starting with Hugh.
Thanks. I started out with that observation about the general advice that we end up with, that unless you're really into doing refugee work, it is worth considering using and involving charities who are out there who do have expertise in this area. It is quite an involved area. And can I add that I do appreciate the comment from the person who mentioned the Welsh thing. As a half Welshman myself, as Tim knows very well, I'm everlastingly speaking on the Welsh score. So shame on me for having not raised that as a point at the start. And thanks to whoever raised that point.
Thank you. Luke?
Just one comment on the come up just now about giving away the property to, let's say, an overseas charity. Just got to bear in mind things like if it's a UK property, you're giving away, or let's say an English property in England, you're giving away to an overseas charity that don't necessarily have UK tax exemptions. That if it's a connected charity, then there's a deemed consideration between connected parties for stamp duty, land tax. So you could think you're giving away something and there's no charges or anything to it, but there could be an SDLT charge. And I suppose the other comment I would make, it's not necessarily tax related, is that when you're giving property away, often I think sometimes it's what Hugh said about thinking about would you write the check, but also is it's very tempting sometimes if the property is a burden to the charity with all the maintenance costs, everything you have to do if you're a smaller charity, to give it to somebody else who can take on all of those liabilities as well. But it does need to be carefully thought about. Again, going back to the tax side, is are you incurring this expenditure in the best interest as charitable expenditure for your charity by maintaining this property? So giving away may not seem as ludicrous as what people think, or let's say giving it a smaller consideration, a sort of reduced price. But that's probably it from me, other than if anyone's thinking of doing this sort of thing, well, good on you, but hopefully we've opened your eyes, not scared too much. Make sure you do this the right way and involve the right people to do it.
Thank you. Socrates?
I'll keep it short. I think the only thing I would say about VAT is just consider it from the outset and plan accordingly from the outset. If you're going to benefit from reliefs, 9 times out of 10, you may need to issue a certificate. You may need to know exactly what the overall cost is. So think about the VAT position before you start work.
Great. And Paul?
And again, I mean, not wanting to or wishing to make this sort of a difficult difficult procedure, but I think compliance is one of the key takeaways for me in terms of checking, as you say, with your lenders to see whether you're able to sort of sublet or for it to be used similarly for your insurance, to check whether your insurance allow temporary occupation and licensing for the HMO license, that check to see whether that's required. So just generally just ensure that you're complying and you're not in breach of any of your sort of obligations. So I think that would be my point.
And Amanda?
Thanks, Tim. I think the thing that I would say is that it's very easy at the moment to watch the news and to think that we must do something. But this is probably one of those situations where we need to act with some speed, but not haste. And therefore, you do need to sit back and think about it. And I would urge you to think about what the best use of your skills, knowledge and experience and assets are. So as a charity, if you have never housed refugees before, but you've got a surplus property, do think about involving another organisation that probably has experience of housing those refugees, and to lease or to allow your property to be used by that other organisation, but they actually manage all of the housing needs and all of that. But also look at the resources and the skills you've got within your charity, because there are probably other ancillary services that you can provide to those refugees. And one of the things the Charity Commission desperately tries to encourage charities to do is to work together. And there may be skills and resources that you can work with that tenant of your property to provide certain services so that you benefit the refugees, but in a way that you feel comfortable with and that you've got the expertise to provide. I think it's about looking around and thinking about the best use of your charity's resources and its assets, and who actually controls the work that you want those assets to be used for.
Great. Well, thank you to everyone who's been watching in today, and thank you to the panel. Obviously, as Amanda said there, it's a difficult subject. If you do want advice on it, our contact details will be on the recording that's circulated, so do get in touch. But thank you very much for joining us this morning.
Thank you.